5 minutes today.
It's up to you.
Thank you, Your Honor. Your Honor, this case is relatively straightforward, and I'll give you just a little background before I kind of get into the meat of it. Mr. Brock, my client, owns some property in Meigs County, Tennessee that's part of a neighborhood called Red Cloud Development. Red Cloud Development has certain covenants and restrictions that are incorporated into the deeds for that subdivision. Mr. Eick, who's the appellee in this case, he bought his property, I believe it was in 2020, and it also was subject to the same covenants and restrictions. The covenants and restrictions that are at issue today aren't before the court on really what the merits are of those restrictions and what they mean. For purposes of just making it clear, what we're arguing about is whether or not an Airbnb is a business and in violation of the covenants and restrictions. We didn't get to that issue at the trial court, frankly. What came up in the trial court in front of Judge Pemberton was the issue of whether or not all of the property owners in Red Cloud Development had to be parties to the litigation for purposes of a ruling under the Declaratory Judgment Act that Mr. Eick was in violation of the covenants and restrictions. Specifically, 2914-107A is a provision that the court addressed and determined, ruled, and said, in order for this court to have subject matter jurisdiction over this case, we have to have all of the residents and property owners, in the Red Cloud Development to be made parties to this action. Now, we obviously opposed that position. In the record, you'll see that we essentially conceded, at least for purposes of the motion to alter or amend, or the order on that we weren't going to be able to sue everybody in the subdivision. It was some 200 property owners was our position at that time. But that's really kind of beside the point. This case in the covenants and restrictions provides specifically that Mr. Brock, my client, had the right as an individual property owner to bring a cause of action in law or equity against Mr. Eick for purposes of enforcing the covenants and restrictions. It's very clear, it's not ambiguous, it is plainly stated that he had that right. It is not that a homeowners association had to do that, it's not that some other group of people, it's not that there was any type of approval necessary. It was that he individually had the right to bring that cause of action. And so when we look at the court's opinion or ruling on the issues regarding dismissal, what the court did is it took two cases in particular to reach the conclusion that all the property owners were necessary and indispensable parties to the proceeding. And that was the DeBruce case, which I've provided some briefing on to this court, which was dealing with the Declaratory Judgments Act and whether or not an individual had a right to be a party to a proceeding wherein it was determined by the court that an insurance carrier was not responsible for providing a defense to someone. And the Court of Appeals, quite frankly, ruled in that case that it was necessary that the injured party, if you will, in an underlying car accident was to be a party to the declaratory judgment action because they had an interest in that proceeding. The case went up on appeal to the Supreme Court. I know your honors are aware of these things, but I'm just trying to talk through it. But it went up to the Supreme Court, and obviously the Supreme Court said, no, that's incorrect. The necessary and indispensable parties who actually had a real interest at issue in this case were properly before the court without the injured party in the lawsuit being a party to it. That case was what resulted in Judge Pemberton ruling that all of these people that are members of the Red Cloud Development should be made parties. And with respect to the court, I think it took an overly simplified approach to the issues in our case. And it basically picked out some of the language from the DeBruce case to say, this is why I think that we need all of the party or all of the owners to be a party to this case. But it really didn't look at the facts and the analysis that was underlying that DeBruce matter.
Excuse me for interrupting,
yes,
counsel. As I understand in this case, there's not a homeowners association for this development. Is that correct?
I believe that's correct, Your Honor.
How does that impact this issue?
I don't think it does, particularly in relation to the language in the covenants and restrictions that provide an individual property owner the right to bring an action individually. We didn't get to that when it came to a briefing issue. I know that's an issue that's been raised, at least in the reply brief by Mr. Eick. But I don't think that has any bearing whatsoever on...
What would prevent repeated litigation by numerous homeowners on the same issue?
Well, when we talk about the issue, I think that's before the court, at least at the trial level I'm here today, the issue was whether or not Mr. Eick and Mr. Eick alone was in violation of the covenants and restrictions. We just alleged that he was operating his business in violation. We didn't know the underlying facts. For purposes of this appeal, I think the appellee has conceded that he's operating a short-term rental, and we believe that's in violation because it's a business. But, you know, from the standpoint of where we were at in the litigation, the issue was between Mr. Eick and Mr. Brock, as opposed to the whole of the neighborhood. And it's important, I think, to look at these cases in the way intended by the Declaratory Judgments Act to provide people speedy relief. It's not could it, but would it affect other property owners? There's nothing that's before any court that says that anybody out there actually has another interest in doing anything like this in violation of the covenants and restrictions. But if the Declaratory Judgments Act obviously says, look, if there's a ruling on a case and you're not a party to it, well, these judgments don't prejudice you in terms of whatever issues may come up in the future. That was contemplated by the legislator when it wrote these rules for us to follow. But I think it doesn't change the scenario where when we look at the types of cases and issues involved in analysis, which I think DeBruce, I think Largen also brought up, that it supports the conclusion that the court just overstepped its bounds when it said that all of these people have to be a party to this proceeding, because the practical effect of that, and if this court was to say, and obviously it's within this court's prerogative, if the court says, look, absolutely, every single person in this subdivision had to be made a party for the court to rule on this one issue, well, that is a broad swath that will affect a lot of people and will generally render, I think, covenants and restrictions enforcement to be unenforceable absent all property owners in every subdivision being made parties, which I think is something that is not intended by the Declaratory Judgments Act nor the legislature.
Well, let's look at this for a minute. Assuming you lost the suit and the court ruled that it was all right, it's not a business, then what about your neighbor? Could they later file the same suit against that party?
You're talking about another neighbor against someone else? Well, I believe that they could, sure. Well, but the facts would be different. I mean, the facts in one case related to whether or not they're in violation of the covenants and restrictions could very well be very different from the facts in the case for Mr. Brock and Mr. Eick. That's what's unique, is that we can't just look at it in a vacuum and say that this right here is the singular issue that could come up with this specific set of facts in every single one of these circumstances. I mean, if you take that rationale and you apply it to DeBruce, well, every single insurance person with a policy of insurance in that case would be a necessary party to that proceeding to interpret the terms of the policy. That's not what's ever been the law, and I don't think that's what's intended by the Declaratory Judgments Act. But we have to, and the courts have said routinely, that we have to look at the issues as well as what the facts may be in each of these cases in order to make a case-by-case decision. And that's what I think is appropriate in this set of circumstances to support the conclusion that Mr. Eick and Mr. Brock have the only real issues that are here for the court's consideration at this point, and to expand it and say, well, everybody in the neighborhood has to be a party in order for us to determine whether or not Mr. Eick is in violation exceeds the scope of what I think the Declaratory Judgments Act provides. Happy to answer any more questions, but thank you.
Hey, you're not. Ready? Thank you. You have your rebuttal time.
Thank you.
Yes, sir.
Good afternoon, Your Honors. Ben Rose on behalf of the appellee, and as a native of Sevier County, I would be remiss if I didn't say I'm happy to be back in East Tennessee, so I appreciate you hearing us. Your Honor, to answer Judge Frierson's question, this is Largen. That's what this case is. The main issue here, I want to talk about some other things, but the main issue is obviously whether or not, as it relates to the declaratory judgments action, there's subject matter jurisdiction here because, given multiple opportunities, Mr. Brock did not join the other property owners or lot owners within Red Cloud Development. It's the same case. I think I said in response to the motion to alter amend that was later filed that this is not the trial court's first rodeo and it's not, because Judge Pemberton, of course, was the trial judge in Largan. So I think he has a pretty familiar grasp or comfort level with regard to these types of decisions. DeBruce also applies. I would point out some of the discussion that my counsel opposite had related to DeBruce. The reason there's a distinction is even DeBruce says, Justice Lee says, that if there was a judgment against the insured, the claimant in that particular case would be a third-party beneficiary. And if you're a third-party beneficiary, then the level of interest is enough such that you would have to be joined within the lawsuit in order to have subject matter jurisdiction under the Declaratory Judgments Act. That's exactly what we have here. Counsel has conceded, there was a little bit of a dispute below on this issue about the Homeowners Association, but counsel has conceded before your honors this afternoon that in fact, as we all know, and it wasn't disputed, there is no homeowners association associated with this loosely affiliated Red Cloud development. Without a homeowners association, the only theory, indeed, Mr. Brock in his briefs concede that in fact the gravamen of this action is a contract action. They claim that Mr. Brock is a third-party beneficiary to the governing covenants within the development itself, and that's how they evoke the power and authority to impale upon my client certain requirements, at least under their interpretation of how the short-term rentals work within the state of Tennessee. So that is their theory. They are third-party beneficiaries to the covenants, and if you are a third-party beneficiary, as per DeBruce and Largan, you are required, in order to get subject matter jurisdiction under the Declaratory Judgments Act, to be added within that proceeding. And I think that's simply what Judge Pemberton did.
But how are they a third-party beneficiary and not a direct party to the covenants? I mean, all of the property owners are directly bound by the covenants and restrictions they run with the land whenever they purchase property. So how does that make them third-party beneficiaries?
I would defer. First of all, the record is pretty thin on those issues, Your Honor. I had to sort of make some leaps. That's essentially, I would tell the court that's essentially what the theory is. I think I would leave it upon them to try to articulate that. That's the best I can do based on the meager pleadings that have been filed in the case.
Let me ask you this too. I mean, let's say the challenge from the one of the neighbors was not to whether or not he's running an Airbnb or renting out his house. What if there's a restriction that says you can't park your boat in your driveway, and a neighbor sues and says you're in violation of this restriction, a declaratory judgment action saying you violated this by parking your boat on your property? Does everybody need to be made a party to something like that as well?
Well, of course, that's not what we have here, Your Honor. It's the first response to your question that we always answer when judges ask those questions. But I think it would depend. I think that's a broader issue, and I understand the court's trying to evaluate exactly how this works, given the minor infraction versus more substantive infraction. But I would submit that likely scenario goes deeper than that. It probably goes to the more substantive provisions within the covenants themselves. And I think that the problem you have is frankly what Judge Frierson said, is that if the trial judge entertains this particular complaint and puts down a declaratory judgment ruling, you're going to get flooded with tons of other people saying, well, wait a second, I don't put a boat, but I've got a Winnebago, I've got a this, I've got a that. So I think that is the problem, and it's not so much a problem with the courts, Your Honors, as this is a loosely affiliated or organized development. And unfortunately, I mean, typically we have situations where a homeowners association or a property owners association can handle that. And we've even cited cases where there's joinder even in those circumstances where perhaps the HOA does not represent all of the interest or the core interest of the members. So even there, when you have a formal HOA or POA, you could have a situation where you still need to join in order to get jurisdiction. But I think that's the problem we have here. The central problem is this is a loosely affiliated development that just doesn't have that type of formal representation such that the courts can be assured that, hey, when I'm going to make this decision, it's going to stick and apply to all of the members, as opposed to a flood of litigation, which the court specifically cited within his initial order. And that, again, largely reflects the concerns that were in the Largan case. I want to take it a step further, though, because I think there are more issues that are involved here. And if I could, just let me step back in the time I have and briefly kind of outline where this case started and sort of where it ended. This case originated with a complaint being filed that essentially had no cause of action. It was just a bunch of facts, the covenants essentially between these two parties, and a request for injunctive relief, a one-sentence request for injunctive relief. We filed a motion to dismiss, our initial motion to dismiss. That motion was based upon jurisdiction, whereas typically chancery courts have jurisdiction over these types of questions, and then also a substantive issue related to the one-sentence request for injunctive relief not being a cause of action. Subsequently to that, there was a motion to amend that was filed, and then subsequently an amendment as of right, which the trial court allowed. We took issue with that and take issue with that decision and this appeal. But in any event, there was an amended complaint that was filed. And in the amended complaint that was filed, there was a specific request for declaratory judgment relief, but then there was still the one-sentence claim for injunctive relief, and then another claim that I'll sort of describe it as a nebulous claim for damages and other types of relief under the covenants that was brought on behalf of Mr. Brock and others. That's the literal language of the amended complaint. So this is a lawsuit not just on behalf of Mr. Brock, but other unknown individuals within the development itself. We filed a motion to dismiss not only based on the Declaratory Judgment Act subject matter jurisdiction question, but also on the substantive, what I would call the 12026 issues related to the legality of short-term rentals, which we think is still an issue, the one-sentence claim for injunctive relief, and the nebulous claim that frankly wasn't articulated in the form that's required by the courts of this state. The trial court, after a lengthy hearing, ruled in our favor and put down an order that granted relief as it relates to the Declaratory Judgments Act. But the court dismissed the case after giving Mr. Brock a period of time to add these other lot owners, dismissed the case with prejudice. And we submit that in doing so, what the trial court did was granted our entire motion, both the jurisdictional and the substantive portion of the motion. The reason for that is the trial court would have never granted that motion with prejudice had it just been jurisdictional. It would have been without prejudice. There then was a motion to alter amend that was filed, and in the motion to alter amend, the court makes a change with regard to the HOA, and that's where we take the issue with regard to a factual challenge versus a legal challenge based on the pleadings. And then the trial court also changes the designation to be without prejudice. We have argued, and we submit to this court, that ultimately in doing so, the trial court erred in denying relief as it relates to those substantive claims in addition to the jurisdictional claims. We would ask the court to affirm the trial court's ruling as it relates to the Declaratory Judgments Act, excuse me, and also the substantive claims under 12.026. Thank you.
Thank you. Your rebuttal.
I'm going to start with what I think is the easiest part first, and I put it in my brief, but these additional issues beyond the subject matter jurisdiction weren't brought up at any point in the proceedings before the trial court, and they were waived. That's our position on that. With regard to the substantive issue of whether or not a short-term rental is in fact in violation of the covenants and restrictions, we even said that was waived, but asked this court to remand this case with an order that, in fact, they conceded at this point that they're operating a short-term rental, and that is a business under Tennessee law. So they're in violation of these covenants and restrictions. And that's why we're asking this court to send this case back on remand so that we can have a hearing to conclude this matter and uphold what the covenants and restrictions require and what the law of Tennessee is. The Largent case is not this case. The Largent case is a fascinating case in that someone challenged whether or not the city of Harriman was properly annexed back in like the 50s. And if anybody believes that every single person in the city of Harriman didn't have an interest in that case, I think that respectfully, they're just lost because it would have affected all of them. It would have taken away the annexation of the city. That's not what we have here. We're here asking this court, or better yet asking the trial court, we're asking you to send it back to decide whether or not Mr. Eick is in violation of covenants and restrictions, not some other person in the neighborhood, not, we're not asking for a blanket ruling that what he's doing is in violation. What we're trying to do is make sure that he cannot operate his business in violation of the covenants and restrictions. And with due respect, when we filed our initial complaint, we alleged breach. But the train started rolling down the tracks, and it looked like we were about to get dismissed. If the court looks at the order from that first motion to dismiss hearing, I think there's even a comment in there about that. And I disagree with that, but we were trying to preserve this case and expeditiously move it along for relief. And so with regard to this third-party beneficiary argument, I don't know where that's coming from. We are a direct beneficiary of the covenants and restrictions. We have express rights under the covenants and restrictions. It's in our deed. We've been there, my client that is, has been there for an extremely long period of time for Mr. Eick to come in and upend the apple cart, so to speak. And so we're just asking for this to get back into a posture where we can enforce rights which have existed for a long time against a property owner who's not abiding by it. Why is there no HOA? I can tell you, when these covenant restrictions, I think, were entered back in the 50s or 60s, nobody knew what an HOA was. That didn't exist. That wasn't a concept that was within the realm of knowledge at that point. We've obviously advanced over time. And if the court's position is that an HOA matters, well, the court needs to also say that that HOA supersedes the rights of people that have a direct interest in covenants and restrictions as it relates to older ones that didn't contemplate the HOA. We are just wanting this court to recognize that the dispute is between Mr. Eick and Mr. Brock, and that he has a right to bring this action to enforce the covenants restrictions. Looking at my notes, I'm sorry. Are there any other issues that I can answer for the court? I hope I've addressed everything.
I hear none. Thank you very much. I want to thank you both for your presentation and your argument. Your case now has been submitted to the Court of Appeals.